Okay. First of all, let me apologize that your original speaker, Rudy Asensolo, wasn't able to make it today. He suddenly fell ill, but we wanted to make sure that we had a presence here to provide some training in this very important conference that you all are participating in. So, as Jennifer mentioned, this is kind of a first that we're trying to work through some of the nuances of the technology that the government gives us. So hopefully this will work. My name's Kristina Miller, and I am with HUD's Office of Fair Housing and Equal Opportunity here in Seattle, Washington. And I have the privilege to present today on Section 3, and I would like to go ahead and move forward, and let's discuss Section 3. The first thing to understand is what exactly is Section 3. It is a provision of the Housing and Urban Development Act of 1968. And the purpose of it was to promote local economic development, neighborhood economic improvement, and individual self-sufficiency. So that's what Section 3 is, but there's a lot to it. And I think we must begin with the history of Section 3 for us to get a good context, if you will, of where this law came from and why we have it, because I always feel that it's important to understand the purpose and the goals of laws to understand. When we get into the nuances, it's oftentimes easy to forget what we ultimately are trying to accomplish. So to help us understand what we're trying to accomplish with Section 3, I'd like to discuss the history. And it really revolved around the civil rights issues occurring in the 60s. There were a lot of urban conflicts, for those of you that are old enough to remember, and those of us that aren't quite old enough but have studied history know that the 60s were a very tumultuous time. One of the results of what happened is that there was a commission to determine why was there so much unrest. And as you might imagine, there are a lot of layers and a lot of complexities to that. But one of the things that was found by the Kerner Commission was that part of the issue was economic depression, if you will, a lack of jobs. So the Kerner Commission called for legislation that would stimulate jobs and business opportunities for residents of assisted housing in distressed urban areas. So one result of the analysis of what was going on was to address it through economic stimulus by jobs. The result of that was Section 3 of the Housing and Urban Development Act of 1968. But unfortunately, that law didn't have a lot of effect. It did little until the civil disturbances in Los Angeles in 1992 that refocused public attention on the same issues that we were seeing in the 60s. So the Housing and Community Development Act of 1992 served to overhaul Section 3 by clarifying the types of HUD financial assistance, activities, and recipients that are subject to Section 3. And we happen to be here during an exciting time in that there's going to be another box, if you will, on this arrow of the history of Section 3, because we are going through yet another evolution on the iteration of Section 3. But stay tuned, and I'll talk about that shortly. For now, I want to share the intent of Section 3, okay? This is a HUD rule, a HUD law, Housing and Urban Development. And one of the things that we looked at under Section 3 is how we can use the HUD investments to harness the economic power and expand economic opportunity for low-income individuals in the neighborhoods where they live. And it's recognized that HUD-funded activities represent one of the largest sources of economic activity in many low-income and distressed areas. the economic benefit to these areas will multiply to the extent that HUD's monies, HUD's investment circulates throughout the neighborhood economy as not just wages and income to the families, but also as contracts to businesses, as sales for others in the neighborhood where these residents and businesses buy their goods and services. So it's a trickle-down effect where we are trying to multiply the effect, the positive effect of HUD monies, not just in the housing and urban development area, but in the economic development of low-income individuals and in the low-income neighborhoods where they live. So ultimately, that is our intent under Section 3. And specifically, we are looking to help more families move toward economic empowerment and self-sufficiency by directing economic opportunity to those low-income individuals. And the goal here is long-term economic growth of the individuals and of the neighborhoods by developing the skills and capacities of the workforce. So we don't want to just provide affordable housing. That is critical. But we want to give individuals the tools to be able to move out from the subsidized housing arena. And so the goal of Section 3 ultimately is for the recipients of HUD funds and the contractors they use to direct employment and other economic opportunities to Section 3 residents and Section 3 businesses when there is a need to employ additional personnel. Okay, so that is the ultimate goal, but we need to break this down to help us understand the various aspects of Section 3. Before we do that, though, as promised, this is the next evolution, if you will, the next iteration of Section 3. Very recently, just on March 27th, HUD issued a proposed rule, and it is currently open for public comment. So it's not a final rule yet, but in the proposed rule, HUD seeks to clarify the obligations of our public housing authorities and other HUD grantees. It's looking to incorporate HUD programs that have been created since the publication of the regulation in the 90s. There's been a lot of new HUD programs that are covered under Section 3 but aren't specified in the existing regulation because they weren't in existence at that time in the early 90s. The proposed rule also looks to codify the best practices that we have seen proven successful throughout the nation in employment and contracting opportunities. HUD is very eager to get the public's comments on this new proposed rule, and I would encourage you to take a look at this website where you can read the proposed rule and also have an opportunity to comment on this proposed rule. If you aren't able to write down the link right now, feel free to email me at kristina.miller@hud.gov, and I'll be happy to forward the link to you so that you can take the opportunity to issue a public comment during the open period, which is 60 days from March 27th. So as you can see, we're in that process right now. Because it is a proposed rule, we're not at liberty to discuss the details of it, but HUD does plan to host a series of webinars to get input from our stakeholders and our community partners about this rule. What works, what doesn't, what can we do better, okay? Now, in the meantime, all right, this proposed rule, as I implied, is just a proposal right now. There's a lot of steps that have to be taken before it can become a finalized rule. It will take a long while, I would imagine. So until that rule is finalized, the existing Section 3 regulations are still in effect, and that's what we're going to discuss in detail today. I will say, regardless of the proposed rule, the ultimate goals and the intentions will remain unchanged of what we've just discussed, harnessing the economic power of HUD to not only to increase housing and urban development, but to also increase the economic development of the individuals and the neighborhoods in the distressed neighborhoods. Okay, so the ultimate goal remains the same. Now, with the existing rule, there's some key elements that we need to discuss to help us understand what Section 3 is all about and what it requires. The first is to understand who Section 3 helps. And I think we've made several references already to give us some understanding already, but we'll reiterate and detail more specifically. Then we will talk about who must comply with Section 3. Then we will discuss the Section 3 requirements, and very important, how do we comply with Section 3? So, first of all, okay, very important is to understand who are we trying to help under Section 3. The first group are Section 3 residents. Now, Section 3 defines a Section 3 resident as a public housing resident, a resident of the public housing authority. Or it could be a low or very low-income person residing in the metro area or the non-metro county in which the Section 3 covered assistance expended. So that would be, the city of Boise, or if it's outside the city limits of Boise, perhaps Ada County, okay? Depending, I'm just using it as an example where you guys are at. Okay, so basically, we're trying to help low-income individuals under Section 3. And when we say Section 3 residents, we are referring to low-income individuals. The primary focus is going to be those residents receiving HUD subsidies through public housing. Now, the other group that Section 3 seeks to help are the Section 3 businesses. So we are trying to help individuals, but also businesses to grow their companies. So currently, Section 3 defines a Section 3 business in one of three ways. It's one or the other, okay? It could be a business that is 51% or more, in other words, majority owned by Section 3 residents. Okay, oftentimes, it's a small mom and pop business. Maybe they do drywall, maybe they're janitorial. They're a small business, the majority owned by low-income individuals. A Section 3 business could also be one in which 30% or more of the full-time employees are Section 3 residents. Okay. Lastly, a Section 3 business could identify itself as such on a project-by-project basis. Whereas when there is, let's say, a construction job and a general contractor submits a bid proposal, in that bid proposal, they commit to subcontract at least 25% of the dollar amount of that contract to Section 3 businesses that meet the requirements above. So how would that look? Well, simple math. Forgive me, I have to use simple math. Let's say the job bids for $1 million, okay? And if it bids for $1 million, the business, in this case the general contractor, would have to commit to at least, $250,000 of subcontracts to Section 3 businesses in order to be considered a Section 3 business. And that's very possible because, as you will see, a large part of the Section 3 activity is construction work. And if you are building a new multifamily housing project, for example, a general contractor is often going to subcontract some of the smaller jobs, like landscaping or not landscaping, that's not necessarily a small job, but if, say, someone's installing the blinds in the apartment unit, somebody's doing the janitorial work. There's a lot of work that oftentimes gets subcontracted. So this last element allows for businesses on a project-by-project basis to be considered a Section 3 business. The ultimate goal, though, is that the monies are being used to boost the economic development of low-income individuals. Now, very recently, HUD has established on its website a Section 3 business registry. It was actually piloted in the last couple of years in some cities outside of the Northwest, and with its success, they've decided to open it up nationwide. One of the key areas of concern for HUD recipients and their contractors is how do we find Section 3 businesses? So the online business registry was one means to do that. It's a searchable online database that lists businesses that have self-certified that they meet one of the regulatory definitions of Section 3 businesses. Okay? We are pushing really hard right now to get folks to spread the word about this Section 3 business registry, to get folks to get in there and register their businesses. This way we have in the Northwest and on a localized level a very big group from which to draw from on Section 3 businesses to do Section 3 work like construction. So please spread the word about this new online business registry. It's a great tool for our HUD recipients and the contractors who work with us to find Section 3 businesses. Now, keep in mind, it's a self-certification process. So if you draw from this list, you still need to verify that they are in fact Section 3 businesses, and most importantly, you have the right to verify that they have the ability to do the work. And we're going to talk about that here shortly. Okay? All right. So we understand who we are helping under Section 3, then who must comply with Section 3? There's two sets of groups. The first are HUD recipients and subrecipients, which are any entities that receive Section 3 covered assistance directly from HUD or from another recipient. All right? And we're going to talk about what Section 3 covered assistance is here shortly. This differs from contractors and subcontractors. Now, they also must comply with Section 3. These are the entities that actually perform the work or a portion of the work that's generated by the expenditure of Section 3 funds. Okay? So they're the ones out there swinging the hammers, doing the bricks and mortar work of the construction jobs. All right? So it's important to understand these distinctions because when we talk about the requirements under Section 3, it's important to know, am I a recipient or subrecipient, or am I a contractor and subcontractor? And the chances are, if you're out there doing the work, you're the contractor or subcontractor. Okay? All right. So, as we mentioned just a moment ago, when we talked about recipients and HUD recipients, we were talking about Section 3 covered assistance from HUD. Here are the two groups of HUD financial assistance covered under Section 3. They are covered recipients who receive public and Indian housing funds and covered recipients who receive HUD housing and community development funds. There are these distinctions because the requirements under Section 3 differ depending on which type of funding you receive. Under the public and Indian housing, Section 3 will apply to all public and Indian housing programs and all of the contractors who receive awards from the public and Indian housing funds. The only exception to this are public housing authorities that only administer the Section 8 Housing Choice Voucher Program. They don't administer, say, public housing units or any other programs. Okay, that's the only time, the only exception. Under this provision of Section 3, under public and Indian housing recipients, anytime such a recipient uses even $1 of their funds towards development, operation, or modernization assistance, they must then give preference to Section 3 persons and businesses in training, employment, contracting, and economic opportunities. So again, anytime monies are used for new development under development funds, or The operation funds for day-to-day business or modernization funds for rehab. You must give preference to Section 3 persons and businesses. Okay? Basically, Section 3 applies to nearly all aspects of public and Indian housing, and there is no threshold. It applies to public and Indian housing recipients regardless of the size or number of units, and it applies to all contractors awarded contracts for public and Indian housing funds regardless of the contract amount. All right? This is going to be a big difference than what you're about to see under the Housing and Community Development provision of Section 3. When we talk about housing and community development assistance under Section 3, we're talking about recipients of housing community development funds, such as Community Development Block Grant Funds, otherwise known as CDBG. And this includes CDBG funding for Indian tribes and Alaska Native villages. It could also be funding for housing opportunities for persons with AIDS, which we refer to as HOPWA. It could also include Section 202 supportive housing for the elderly or Section 811 supportive housing for the disabled. Housing and community development funds also include HOPE 6, Home, Continuum of Care, and self-help of home ownership opportunity programs. Okay, so these are a sampling of the type of HUD funds covered under housing and community development assistance. Now, this is one area you will see in the proposed rule that's going to be expanded, because when this originally came out in the early 90s, there were a lot of programs that have since become effective that are on this list, because at the time, the regulations, the funding didn't exist, so the regulations had no way of covering them. It is understood that these programs that have come into inception since that time are covered under Section 3. But the proposed rule aims to specify that these programs are covered. It becomes more than an assumption. Section 3 also does apply to recipients of the Indian Housing Block Grant Funds, which are regulated by the Native American Housing Assistance and Self-Determination Act, otherwise known as NAHASDA. Now, NAHASDA allows Indian Housing Block Grant recipients to give preference to Native Americans. This is not in conflict. This is not in conflict with Section 3. Basically, Section 3 says that Indian Housing Block Grant grantees should provide employment opportunities to low and very low-income Native Americans and to businesses that are either owned or substantially employed by low or very low-income Native Americans. Okay, so they can work in conjunction with each other and not conflict with NAHASDA. Okay, so here's where we see a key difference between recipients of public and Indian housing funds and recipients of housing and community development funds. All right? If you recall, if you are a recipient under public and Indian housing funds, there are no monetary thresholds. You're going to be covered under Section 3 anytime you use the development, operating, or modernization funds. If you are a recipient of housing and community development funds, all right, you are only covered under Section 3 if you receive more than $200,000 of these funds as a recipient or subrecipient. In other words, you're receiving the monies directly from us at HUD, or you're receiving them from a direct recipient. Oftentimes, we see that HUD gives funds to the state, and then the state gives funds to the local cities. The cities become the subrecipients, whereas the state is the direct recipient. The threshold is the same for both. If you receive more than $200,000 of HUD, Housing Community Development Funds, then you are covered by Section 3. For contractors and subcontractors, the one actually doing the work, they are covered by Section 3. If their contracts with the HUD funds is more than $100,000. Okay, so this first block is who's covered under Section 3. The second block tells us when Section 3 is triggered. That is, if even $1 of the Housing and Community Development Funds is used toward development, renovation, rehabilitation, or modernization, then Section 3 is triggered. And that means then that the recipient, subrecipient, and contractor, subcontractor must now give training, employment, contracting, and other economic opportunities with preference to Section 3 residents and Section 3 business concerns. Okay? Now, keep in mind that Section 3 is triggered only when you're actually doing development, renovation, rehab, or modernization. Okay? Does not mean you have to create a situation in which Section 3 is triggered. It's just a matter of if you use even $1 of the Housing and Community Development Funds, then you must give preference when hiring or awarding contracts to do the work. You must give preference to Section 3 businesses and Section 3 residents. Okay? So we have a sense of who we are helping under Section 3, and now we have a sense of who must comply and give that economic boost, if you will, to those that we are helping. Okay? So we talked about Section 3 residents and businesses. We talked about who the recipients are, subrecipients, contractors, and subcontractors. And then we talked about the different coverage of Section 3 depending on if you are a recipient or contractor working with public and Indian housing funds versus a recipient or contractor working with housing and community development funds. So if you know you're covered, you know that you spent even $1 on development, renovation, rehab, or modernization, and you know that Section 3 now is triggered and you must comply with the requirements of Section 3, then the next question is, what are those requirements? Okay, these are pulled right out of the regulations that are currently in existence. And the requirements are, you must notify Section 3 residents about the availability of training or employment opportunities. Similarly, you must notify Section 3 business concerns about the availability of contracting opportunities. And you must notify contractors about the Section 3 requirements, and what's more, notify them about their responsibility under Section 3. And that is done by incorporating the Section 3 clause in all contracts. And the Section 3 clause is built into the regulations. So you need only do a copy and paste and make sure that clause is incorporated in all contracts. The requirements continue by saying that you must train and employ Section 3 residents. You must give preference to Section 3 residents when there is a need to hire, okay? Section 3 does not require recipients or contractors to make up jobs. It simply says that if you need to hire new personnel to do the work, then in that process you must give preference to Section 3 residents in the employment of those jobs. But it is understood that the Section 3 resident must still meet the qualifications of the position to be filled. Obviously, and particularly in some construction work, it's very skilled. You wouldn't want a non-qualified person to do electrical work, right? So it is understood that while you have to give preference to Section 3 residents, you should give preference to qualified Section 3 residents. The Section 3 residents must still be able to do the work. Similarly, you must give preference to and award contracts to Section 3 business concerns. But again, those Section 3 business concerns must be qualified. In other words, excuse me, they must have the ability and the capacity to perform successfully under the terms and conditions of the proposed contract. So they have to be able to do the work and qualified to do the work. And if you have a qualified Section 3 resident or a qualified Section 3 business, then you need to give them preference in awarding the contract or awarding the job to them. And as with all things government, you must document your actions to comply with Section 3. Okay? And regardless of who you are, if you're a recipient or subrecipient, contractor or subcontractor, you should be documenting all actions to comply with Section 3. Now, the other requirement is submitting an annual Section 3 summary report. Now, only the direct recipients have to submit the annual Section 3 summary report to HUD. But that recipient, in their report, must be giving us information about their subrecipients, their contractors, and subcontractors. And so that recipient arguably should be asking for that information from the subs and the contractors and the subcontractors. And that is why it's important that they be able to document all actions. All right, now, let's talk about complying with Section 3, all right? One of the first slides when talking about the intent of Section 3 was to give preference to Section 3 businesses and residents to the greatest extent feasible. So the greatest extent feasible is the compliance measure for Section 3, and there's two elements to it. The first is numerical goals. But if you can't meet the numerical goals, there's something called best efforts. So let's start with the numerical goals. If you're able to meet these numerical goals, then you are in compliance with Section 3. The first one is that in the training and employment of Section 3 residents at all job levels, you should have at least 30% of the total new hires be Section 3 residents. That is, at least 30% of the new hires, which is defined as full-time employees for permanent, temporary, or seasonal employment, should be given to Section 3 residents. Okay? So again, 30% of the new hires should be Section 3 residents. New hires is defined as full-time employees for permanent, temporary, or seasonal employment. To encourage long-term employment, recipients and contractors may count a Section 3 resident for 3 fiscal years. So, if a person is hired, say, in 2015, and at that point they are hired, they are a Section 3 resident, we are encouraging you to keep them employed continuously for 3 years at least, and to reward that as an incentive, you can count that person as a Section 3 resident in this year's report, in 2016's report, and 2017's report. So that's 3-year reports, okay? So even if, and hopefully, that they are continued to be hired, that their employment then brings them out of being low income. Okay, well, that's our ultimate goal, right? We want them to be employed and not be low income. So even if in 2016 they're still employed with you, which we hope they are, and they're no longer low income, you can still count them. And that is an incentive to keep them on board long term. So what kind of new employment opportunities are covered by Section 3? Well, for the public and Indian housing programs, all employment opportunities generated by operating, capital, and modernization funds, including management and administrative jobs, technical, professional, construction, and maintenance, are all considered employment opportunities under Section 3 at all levels. For housing and community development funds, new employment opportunities will consist of all employment opportunities arising from and in connection with housing rehab, housing construction, In other other public construction, including management and administrative jobs, technical, professional, building trades, and non-construction jobs. Okay? What is other public construction? Basically, infrastructure work such as water and sewage lines, sidewalk repairs, site preparation, installing conduits, etc. Okay? So, 30% of new hires. If you have a need to hire new personnel to do the work, to meet this numerical goal, at least 30% of those new hires is Section 3 residents. Similarly, then, there are numerical goals for the contracts, which states that at least 10% of the total dollar amount of Section 3 covered contracts for building trades work for things like maintenance, repair, modernization, development of public and housing, or building trades work in connection with housing rehab, housing construction, and other public construction under housing and community development shall be awarded to Section 3 businesses. So again, 10%. And then the existing rule says that at least 3% of the total amount of non-construction Section 3 work will be awarded to Section 3 businesses. Non-construction work includes things like maintenance contracts, lawn care, routine maintenance, HVAC servicing, and other professional service contracts associated with construction, like architectural, engineering, legal services, accounting, etc. So, in short, the two key numerical values, at least 30% of the new hires are Section 3 residents, and at least 10% of the construction contracts and 3% of the non-construction contracts are awarded to Section 3 businesses. Failure to meet the numerical goals does not equate to non-compliance with Section 3, because there is another element we will consider, and that is your best efforts. Toward that end, we will consider why it wasn't feasible to meet the numerical goals, what the barriers or impediments were despite the actions taken, and what your best efforts were taken to comply. So toward that end, here is a sampling of things that we are going to ask about your best efforts. Where did you post notices and flyers about job opportunities? Did you put them in areas where low-income individuals are going to be, such as the Public Housing Authority office or the public housing multifamily complex? In other words, did you put it in the complexes or units where low-income individuals live, such as HUD-assisted or Housing Authority-assisted complexes? Oftentimes, these complexes will have resident councils. So did you contact those resident councils or other entities about job opportunities? Some housing authorities will have newsletters that go out to their tenants. Did you perhaps inquire about that and perhaps put the flyers and the notices in the housing authority's newsletter or some other entity's newsletter that goes out to low-income individuals? How easy did you make the job application process? Recognizing that sometimes individuals in low-income housing do not have transportation of their own, and perhaps there is no public transportation to get around, that we would say, how easy did you make it? Did you allow for job applications to be delivered or collected where they live? And similarly, did you allow for job interviews to be at these complexes where the Section 3 residents live? Again, this all goes towards how easy did you make it to apply? Did you put up barriers that perhaps would have discouraged Section 3 residents from even trying to apply for the job? And then, There's already some programs out there that are directly related to Section 3. The Youth Build program is for young adults who are low income that learn construction trades, right up the alley of Section 3 residents. So did you contact Youth Build programs? What about the unemployment offices in where you're located, WorkSource or some other unemployment agency? Right? That seems to be a perfect place to put job announcements for work. And then similarly, what were your best efforts in soliciting bids from Section 3 businesses? Okay, much like with the resident information, did you advertise it where low-income businesses might see it? That could include business assistance agencies, maybe the Small Business Association, minority contractor associations, and other organizations. Did you provide notice to all Section 3 businesses for contracting opportunities? And this is where that Section 3 business registry becomes critical, right? As this registry grows, our recipients and subrecipients and contractors and subcontractors can go to the HUD.gov website for the Section 3 business registry and search by, say, the city of Nampa and find all of the Section 3 businesses that have self-certified. You can get their address information, and then you can send them notices about contracting opportunities. And this goes towards your best efforts to comply, the first element being, did you make Section 3 businesses aware of the contracting opportunities? Okay? Now, the unique element of Section 3 businesses is that there's often a bid solicitation that's put out and then a selection process. And HUD, in the Section 3 appendix, located down here below on the bottom of this slide, actually gives some safe harbor, if you will, in establishing whether you gave proper consideration in your selection process. So recognizing that there's two common ways contracts are awarded. One is awarding to the lowest bid, period. You're not taking anything else into consideration, just the price of the bid. If that is the way you select the contract for award, then HUD, under Section 3, asks that you award the contract to a qualified Section 3 business if they bid within 10% of the lowest qualified bid. Okay? More commonly, we see a variety of elements being used in selecting a contractor. All right? And let's say that you take into consideration not just price, but also experience or capacity or other elements. And let's say that you use a point system. So for each qualification, we're going to award X amount of points for a total of 100 points. We would ask that the fact that they are a Section 3 business be given the weight of at least 15 to 25% of the total rating points. And that goes toward the understanding that they can be a Section 3 business, but they still have to meet the other elements of your bid selection process. And if you show that you've given 15 to 25% of the total rating points to award to a Section 3 business, then you've given adequate consideration in your selection process and demonstrating some best efforts to comply with Section 3. All right, so we're just about done here. One of the requirements that we mentioned is submitting the Section 3 summary report. And as I mentioned, that report is submitted directly to HUD by the direct recipients of HUD funding. And that direct recipient will submit one form for each major program funding source. So if they receive home funds, that's one form. If they receive CDBG funds, that's another form. These forms are submitted annually by January 10th, or in accordance with an annual report submission to HUD. like a CAPER if you are a recipient of Community Planning Development Funds. Now, that's not to say that our sub-recipients, contractors, and subcontractors don't have a documentation requirement as well. Our sub-recipients, contractors, and subcontractors should be providing the direct recipient documentation of compliance with Section 3. For example, recipients should obtain certification forms from Section 3 businesses and Section 3 residents. Okay, they're self-certification forms, and it shows due diligence that the verification process was done, okay? And the verification process being self-certification. There are sample self-certification forms for Section 3 businesses and Section 3 residents located on HUD's website that you are more than welcome to use. Now, the official submission of this form goes to HUD's Office of Fair Housing and Equal Opportunity, the Economic Opportunities Division, located in Washington, D.C., in our headquarters. Okay? And it is submitted using an online form. When that online form is submitted, it goes to our Washington, D.C. office. But, unfortunately, the system is broke. HUD tried more than a year ago. HUD tried more than a year ago to enhance the summary reporting system, and some of the things that they were trying to do encountered some technical difficulties. And as of today, as far as I'm aware, they still encountered those difficulties. I think some of it is that they are trying to merge this system with some other HUD programs, and there's a lot of programming involved to encoding to get the two to marry. And not very easy, I guess. I'm not a techie. All I can tell you, it's been more than a year that the system's been down. So what we are asking is that that if you are responsible for submitting reports, keep the documentation in hand. And while HUD will not hold you in noncompliance for not failing to submit the reports right now, when the system does get back up, we will be working with you to submit those back reports. So just keep documentation on hand so when and if, hopefully not if, hopefully it's when the system gets back up, you can easily go in and do what needs to be done. For updated information about the status of that system, in addition, for updates on the status of the proposed rule and any other relevant information on Section 3, I would encourage you to sign up for the newsletter. If you go to www.hud.gov/Section 3, you should be able to sign up for the listserv and also find all sorts of information, including links to the proposed rule and other information on Section 3. Okay? This brings us to a conclusion of our presentation today, and I hope technologically we did okay. You are welcome to contact me with any questions you might have regarding Section 3. My contact information is on the screen, and I'll leave it there for you to write down if you do have any questions. All right, so I'm going to defer to Phil and Jennifer if there's any questions. I think we have one on the Q&A. Should I go ahead and answer that one?
Just one moment, Kristina. A tidbit for those that have to go through an audit for your federal funding. Find the memo or do a print screen of the website about that online and keep it in your file. It makes the auditors much happier that you can just say, here, see, it was broken. That's why I couldn't submit it, and that's why I'm in, quote, non-compliance on the financial audit side. So HUD knows, but not all the financial auditors do. So just a little tidbit.
Excellent point.
Go ahead and answer the question, Kristina.
Okay, so I'm going to read it in case it's real small on your screen. What about when they laid off persons 3 months ago? Do they, the contractor, have to hire Section 3 persons instead of the laid off staff? You know, I think that arguably, if the person who was laid off 3 months ago, if they did not find other work, they are unemployed, they would be low income. And at the point that you put them on the payroll is when we determine if they are a low-income individual. So arguably, if you have laid-off staff, unless they have found other employment, you likely can consider them a Section 3 person because they likely will be considered low-income, and therefore that would be your justification, and then bringing them back on as laid-off staff, previously laid-off staff.
Kristina, a follow-up on that is, presumably, I think this falls to when they may have a spouse who makes quite a bit of income, and so they're not considered a Section 3 employee. Do they have to hire a Section 3 employee, or can they actually hire this laid-off person that is not Section 3?
Well, they have to keep the numerical goals in mind. So at a given time, perhaps they could bring that laid-off person back on, but you have to be cognizant of the 30%. And so if you only have one job available and you automatically give it to a laid-off person who's not Section 3, arguably then you have failed to meet the goals of Section 3. And then you'd have to establish or indicate the best efforts that were taken. So I would say in totality, if it's only one job, you probably need to be cautious of that.
Any questions here in-house for Kristina? Any that have come on over email? Well, it looks like you did really well, Kristina, because there's not a lot of questions.
Either that or I did really bad, and it's really confusing. But thank you all, and I want to thank Phil and Brian and Jennifer and everybody in helping us work through this snafu of staff not being able to make it out there. And I hope that we were able to at least provide some information satisfactorily.
Kristina, we have one question.
Okay.
So the question is what are some best practice tips of looking for compliance? How are you enforcing it? So I think if you're coming out and doing a monitoring, what are you looking for those best efforts to meet compliance when you can't get the numerical goals?
Well, that's an excellent question, and these are some of the questions and some of the things that we will look at when we are trying to figure out the best efforts, okay? These best efforts that you see here, these are some of the questions that we are going to ask. And with that, then, let me just go back a little bit ways here to the requirements. And while I'm doing this, let me just say, if you are interested in receiving a copy of this PowerPoint, feel free to email me and I can send it out. Or I think it might be available on a website. I don't, you might, okay, so apparently it's available on a website. Okay, so if these are the requirements, okay, notifying Section 3 residents, Section 3 businesses, and contractors. So some of the things we're going to look at for this is where, first of all, did you notify them? And where did you put the notification? We don't want to necessarily see that you just put job announcements and bid solicitations in the city newspaper. That's too general. We want to see that you've been creative, if you will, in notifying low-income individuals about these job opportunities in areas where they're going to be or where they are likely to see them. So the slides on best efforts is just some samples of where, you know, we might say, did you put them here, did you put them there? You're not bound by that. We certainly would encourage you to be creative about how you notify Section 3 residents. And again, don't do the generic or the general notification. We want to know that you've been thoughtful about reaching out to low-income individuals. Then, in notifying contractors about Section 3 requirements, we're going to look at the contracts. we are going to look at the contracts that you have with those contractors and make sure that you incorporated something in there about Section 3, and make sure that you've incorporated the Section 3 clause. Okay? And then this last bullet, along with these two bullets, okay, the first thing that we're going to look at is the Section 3 recipient's summary report that you submit to HUD every year. And we're going to look at some of the information on there, which include how many new hires they have, and then how many were Section 3. We're going to do the math and see if you met the numerical goal. If you met the numerical goal based on that report, that's great. When we come to the audit report, we're just going to verify that that's the case. So show us the employment records. If you didn't meet the goal, then when we come on site, we're going to, again, ask for those best efforts, all right? Where did you notify? How did you notify? And then what happened? Why weren't you able to meet the numerical goals? And in which case, you may show us that there were no qualified Section 3 residents who submitted an application, or there were no Section 3 businesses who applied to meet who qualified to meet the job. You show us the documentation regarding that. And as in the best efforts screen, when it came to Section 3 residents, giving them preference, again, how easy did you make it? So we're going to ask about your process, hiring process, and how you go about that. Did you allow for accommodations for persons with disabilities, for example? When it goes to preference of awarding contracts, we're going to look at the bid solicitation and find out, first of all, how did you select your contractor? And then we're going to review the contracts to make sure that there wasn't, in fact, a Section 3 business who was qualified that should have been given preference. Okay, so that's just a quick snapshot of what we're going to look at, and I would encourage you to become familiar with these requirements and then have the documentation to show that, hey, we couldn't comply with the numerical goals, but we did all of these things. We notified residents, we notified business concerns, we told our contractors about Section 3, we were prepared to give preference if we had a qualified business or qualified resident, and here's what we did, X, Y, and Z. So hopefully that gives you some guidance on what to expect in an audit. So is that okay?
So the question is, what are the consequences if you were fraudulent in your reporting or did not use best efforts to meet? What are the consequences for failure?
The very worst consequence is that our recipient can lose their HUD funding. We don't want to go there because the ultimate person punished by that is the beneficiary of the funds, the low-income individuals. So the initial consequence is we would issue what we call a finding of failure to comply with Section 3, and we would try to reach a voluntary compliance agreement to correct the problems. So if you fraudulently reported, depending on how egregious it is, I mean, if it was outright lying to us, we might have to get the Inspector General in or the other program areas in to begin the removal of HUD funds. But I think that we would definitely try to resolve it and fix it through a voluntary compliance agreement, part of which would probably entail us monitoring you quite regularly to make sure that your future reports and your future compliance with Section 3 is actually happening. So we would try to work through it first. We'd issue the finding and then try to resolve it through a compliance agreement. And in the end, if it doesn't work, the ultimate consequence is that HUD could remove the funding from the recipient. Okay. And that can be a big deal.
We have one more question.
Okay.
Okay, so the question is, on a lot of small contracts, they're able, because there's the entity is doing the general contracting themselves. They're able to talk to the small contractors and explain the process and get them certified, self-certified as a Section 3 business. The issue is when you get to the really large projects, you're going through a general with subs who have subs who have subs, and not getting a lot of self-certification as Section 3. Is there a best practices or a good suggestion of how to reach out to them in an effective and efficient manner and not spending 20 days trying to reach every single one of them to walk them through their process, because usually they have no concept of Section 3 or working on federal projects, and so they probably qualify, but they don't know they qualify. Does that summarize it correctly?
That's where these pieces come into play right here, and that's notifying them about the requirements, but incorporating the Section 3 clause in the contract. And that trickles all the way down, from recipient, subrecipient, to contractor, to subcontractor. So it really, it's hard to specify a best practice beyond saying that wherever the funds begin, that entity is responsible for informing the next one in line about these requirements and incorporating the Section 3 clause. At the minimum, they are required by regulation to do these things. So arguably, at the minimum, the Section 3 clause incorporated in the contract should be the notification to the contractors and subcontractors about their requirements under the Section 3 rule. One of the things that I have heard be done is like development meetings. So when a recipient awards to a contractor, they conduct a development meeting with that contractor, and one of the things they discuss verbally is the Section 3 requirements, and then encouraging the contractor to do the same when they have to award subcontracts. That, if ideally they could have one meeting with all the subcontractors, and during that meeting notify them of their Section 3 requirements. But sometimes that's not possible because you may be awarding subcontracts as you're going through the project. So it's up to the contractor really to determine what's the best means in whatever fashion they educate their subcontractors about their requirements. They need to make sure that they're using the Section 3 requirements or incorporating those as well. I don't think, I know that doesn't help a great deal. I think in my experience, what I've heard thus far are the development meetings. And I think that's probably all I would have to offer beyond the regulatory requirements built in. It's the best practice.
Any other questions? It looks like we're done. Thank you so much, Kristina.
Thank you, everyone. Have a great day.
It is